I want you to picture a scenario for me.
Okay, I'm with you.
It's the middle of summer. You're at a neighborhood barbecue, right? Burgers are on the grill, drinks are cold, everyone's having a good time.
Sounds pretty good so far. No legal drama yet.
Not yet. And you're in your neighbor's backyard, and you get into, a conversation about local politics.
Dangerous territory for a barbecue.
Oh, extremely. But you're passionate, right? Maybe it's a new zoning law, something with the school board. You start making your case, you're really fired up.
I can picture it.
And then suddenly, your neighbor, the guy hosting the party, he steps in. He looks you dead in the eye and says, I hate that opinion. Stop talking about it right now or get off my property.
Ouch. Yeah, that is a total mood killer.
Total mood killer. But here's the real question. Your first reaction, besides being embarrassed, is probably indignation, right? You're thinking, hey, this is America. I have a First Amendment right to free speech. You can't just silence me.
It is the most common reaction in the world. I hear it all the time. We all walk around with this idea that the Constitution is this, personal force field.
Right.
That it follows us into grocery stores, onto social media, and, yes, into our neighbors' backyards, protecting us from anyone who tries to shut us up.
But that's the big hook for today, isn't it? Because if that neighbor kicks you out for your political views, has he actually violated the Constitution?
Not even a little bit. I mean, he might be a terrible host.
Definitely.
He might be rude. You definitely shouldn't invite him to your next party, but he has not violated your constitutional rights. Yeah. And that right there is the fundamental misunderstanding we need to clear up today.
Which is?
The United States Constitution is a rule book specifically for the government. It's there to protect you against the state, not against, private jerks.
That distinction, this idea of state action, that's where so many people get lost. And that is exactly what we're going to unpack today. We have a massive stack of legal texts, court rulings, historical documents right here.
We do.
And our mission for this deep dive is to decode that legal force field. We need to figure out when it's actually on and when it's off.
And we're going to do that by looking at 3 huge pillars of constitutional law. Think of them as the 3 legs of the stool that your civil rights rest on.
Okay, what are they?
First, we have to define that term you just used, state action. Who actually counts as the government?
Which sounds simple, right? It's the police or the mayor. But as we're going to see, it gets incredibly messy when, say, private companies start acting like governments.
Well, it's very messy. So that's pillar 1. Second, we're going to talk about procedural due process. So when the government does act, what are the rules of fair play? What steps do they have to take before they can take away your stuff or your freedom?
This is the how of the law, how they have to do it.
Exactly. And third, pillar 3, we'll look at substantive due process. These are the fundamental rights that the government effectively cannot touch, no matter how many steps they take or how polite they are about it.
So that's the difference between you filled out the wrong form to take my house and you aren't allowed to take my house at all.
Precisely. And, understanding these 3 pillars, it really transforms how you read the news. Whether you're angry about a social media ban or you're worried about voting rights or trying to figure out the new gun laws, it all comes back to these mechanisms.
Okay, so let's start at the beginning. The on-off switch, state action. You dropped that bombshell earlier that the Constitution generally only kicks in when the government is involved. Why is that the fundamental rule? Where does that come from?
It really goes back to the very founding of the country. I mean, the framers, they were terrified of a tyrannical government. That was their big fear.
Right, the king.
The king, exactly. They weren't really worried about your neighbor being mean to you. They figured, local laws like trespass or harassment could handle that. They were worried about the state having too much power. So pretty much every protection in the Constitution, from free speech to search and seizure, it begins with the assumption that the state is the potential bad actor.
So state action is the boundary line. If the state isn't involved, the Constitution just stays in its holster.
That's a great way to put it.
Yeah.
And that applies to everyone from the federal government down to your local city council. If a private person or a private company does something unfair, you might have a lawsuit for, say, breach of contract or defamation, but you do not have a constitutional claim.
Now, I'm looking at our notes here, and there is one giant, glaring exception that we have to get out of the way right now.
The 13th Amendment.
The 13th Amendment.
Yes, that's the big outlier. It prohibits slavery and involuntary servitude. And that one applies to everyone. Neither the government nor a private citizen can enslave another person. But that's unique. For almost everything else we talk about, speech, religion, due process, you need a government actor.
Okay, but this is where it starts to get foggy. because that line between private and public isn't always so clear, is it? What happens when a private company gets so big or does so much that it starts to look and act just like a government?
And this is where the courts have had to get creative over the years. They developed what's called the public function, or sometimes the traditional governmental function exception.
Okay, what does that mean in plain English?
It basically says that if a private entity is doing something that is traditionally, and this is the key, exclusively the job of the state, then the law can treat them as the state for that purpose.
The classic story here is Marsh v. Alabama. And I really want to dig into this one because the facts are just fascinating. We're talking about a literal company town, right?
That's right. This was back in the 1940s. I want you to picture a place called Chickasaw, Alabama.
Okay.
It looked just like any other American town. It had streets, sidewalks, sewers, a post office, even its own police officer, a whole shopping district. But the entire thing, every square inch, the dirt, the pavement, the buildings, was owned by a private company, the Gulf Shipbuilding Corporation.
So if you lived there, your landlord was also your boss, and for all intents and purposes, your mayor too.
Exactly. Now, into this town walks a woman named Grace Marsh. She was a Jehovah's Witness. And she went to the sidewalk in the business district, what looked for all the world like a public town square, and she started handing out religious pamphlets.
Which in any normal town is classic protected First Amendment activity.
Oh, 100%. But the company didn't like it. They had a rule against it. They told her, "You are trespassing on private property. Stop distributing this literature or leave." She refused, claiming she had a constitutional right to be there. So she was arrested and convicted of trespassing.
So the company's argument is basically, it looks like a town, but legally it's just our giant private backyard.
That was the argument. But the Supreme Court, in an opinion by Justice Hugo Black, took a very different view. He looked at the reality on the ground, not just the property deed. He essentially said, look, if you open up your property to the public for every purpose, and you perform all the functions of a town, you cannot then suddenly shut the gate when someone wants to exercise their freedom of speech.
So because they chose to act like a government, they had to obey the First Amendment like a government.
Right. But, and this is a really important but for our listeners, that rule is very, very narrow.
How so?
It doesn't apply to just anything that draws a big crowd. Which brings us to the modern equivalent.
Yeah.
The shopping mall.
This is the Hudgens case, right? Because a mall feels like a new town square. I mean, you have people walking around, teenagers hanging out. It's a community hub.
It absolutely feels like one.
Yeah.
But legally, the Supreme Court says it isn't one. In Hudgens v. NLRB, the court looked at a group of union picketers who wanted to protest inside a private shopping mall.
And they got kicked out.
They got kicked out. And they cited Marsh, the company town case. They said, hey, this mall is the new town square. You have to let us speak.
And what did the court say?
They said no. A shopping mall is a business. It does not perform the traditional and exclusive functions of a municipality. It doesn't run a fire department or a sewer system. Its purpose is commerce. So if mall security kicks you out for protesting, that is generally considered private action. No First Amendment violation there.
Wow, that's a huge distinction. So it's not enough to just be open to the public. You have to actually be doing the government's job.
That's the key takeaway.
Okay, let's pivot to another way this can happen, because sometimes the private actor isn't doing the job instead of the government. They're doing it with the government.
This is what the courts call the entwinement or joint venture theory. This happens when the state and a private entity are so wrapped up in each other's business that you can't really tell where one ends and the other begins.
We have a great example here, and it involves something everyone can relate to. High school sports, the Brentwood Academy case.
This is a great case to understand the concept. You had an athletic association in Tennessee that regulated all the interscholastic sports. It set the rules for who could play, recruiting, game schedules, everything.
And technically, it was a private nonprofit corporation.
Right. So when they penalized a school, Brentwood Academy, for recruiting violations, the school sued. And the association's defense was, hey, we're a private club. The Constitution doesn't apply to our rules.
Sounds plausible on the surface.
It does, but the Supreme Court looked under the hood. They asked who was actually running this so-called private club. And it turned out the vast majority of the voting members were public school principals and superintendents, all acting in their official capacities.
Ah.
The state had basically delegated its power to regulate school sports to this private group. The court said they were pervasively entwined.
So you can't just create a private club, fill it with a bunch of government officials, and then use that club to get around the Constitution.
Exactly. If the government's pulling the strings, it's state action.
I want to bring this into the modern era now because, almost nobody lives in a company town anymore, but we all live on the internet. And the biggest questions I see about this stuff are about social media. When does a politician blocking you on Facebook become a constitutional violation?
This is the absolute frontier.
Mhm.
And we have a brand new rule from the Supreme Court on this as of 2024 in a case called Lind v. Freed.
Okay, walk us through the facts of that case.
Okay, so you have this guy, James Freed. He's the city manager of Port Huron, Michigan. He has a Facebook page. He actually created it years ago, long before he was a public official, just to share family photos, talk about his life, normal stuff.
Right.
But eventually he becomes a public official. And like almost every modern official, he starts posting about his work on that same page.
So he's mixing his personal life with his public job.
Completely. He posts a picture of his daughter's birthday, and then right after that, a post about the city's new COVID-19 policies or a downtown improvement project.
And a citizen, Kevin Lynch, he didn't like the city's pandemic response.
That's right. He started leaving critical comments on Freed's posts. And Freed, who didn't appreciate the criticism, eventually just blocked him.
So Lynch sues, and his argument is that by blocking him, Freed violated his First Amendment rights. He was basically arguing that the Facebook page had become a public forum.
Exactly. And the Supreme Court had to decide. When Freed hit that block button, was he acting as the state, or was he just a guy who was tired of dealing with trolls on his personal page?
And they came up with a very specific two-part test.
They did. Unanimously, I should add. They ruled that a public official's social media activity is only state action if two things are true. First, the official has to have actual authority to speak on behalf of the state on that subject.
Okay.
And second, they must be purporting or claiming to exercise that authority in the specific posts in question.
So context is absolutely king here.
Absolute king. If the mayor posts a picture of his cat or talks about his vacation, that is private action. He can block you all day long, and it's not a constitutional issue. But if he uses that same account to announce a new snow emergency declaration or a new city ordinance, something that clearly carries the weight and authority of the state, then he is acting as the government. And he can't shut down criticism in that context.
I really like the way you explained this to me before we started. He can't kick you out of the digital town hall, but he can absolutely kick you out of his digital living room.
That's the perfect way to think about it.
Oh.
And the burden is now on the user, on you, to figure out which room you're standing in when you comment.
Okay, this is super helpful. So we've established who the government is and when a private actor can become the government. Let's move to that second pillar. Let's say we do have state action. The government is making a move on you. What are the rules of the game? This is procedural due process.
Right. The 5th and 14th Amendments have this famous phrase. They guarantee that no person shall be deprived of life, liberty, or property without due process of law.
I've always found the term due process a little bit vague. It sounds like something a bureaucrat says to make you go away. Just trust the process.
It could definitely feel that way. But think of procedural due process like a recipe. It's a set of instructions. It doesn't tell you what the government is allowed to cook. That's the next section, substantive due process. But it tells you how they have to cook it.
Did they preheat the oven? Did they mix the ingredients in the right order?
Exactly. And the two main ingredients, the two core components of that recipe are notice and a hearing.
Okay, explain those.
The government has to tell you, hey, we're about to do something that will hurt you. That's notice. And they have to give you a chance to tell your side of the story. To say, wait a minute, here is why you shouldn't do that. That's the hearing.
But before we even get to the hearing, we have to look at what's actually at stake. The text says life, liberty, or property. Life is pretty obvious. You can't execute me without a trial. But liberty and property are legal shapeshifters. They can mean a lot of different things.
They really are. Liberty is much broader than just not being in jail. It includes your freedom of movement, the freedom to make fundamental choices about your family and your life. But there is a surprising limit here when it comes to your reputation.
Yeah, this one surprised me when I was reading up on it. Let's say the police chief goes on TV and calls me a crook, and it totally ruins my reputation in town. Haven't I lost a liberty?
Common sense would say yes, but the Supreme Court says no, not in itself. They developed what's called the Stigma Plus test.
Stigma plus?
Stigma meaning damage to your reputation plus the loss of something tangible. Reputation alone is not a constitutionally protected liberty interest. The court's reasoning is, well, people say bad things about other people all the time. For it to rise to a constitutional issue, the government have to damage your reputation and take away something else, like your job or your legal right to buy alcohol, for example.
So just being bad-mouthed by a government official isn't enough. You need to lose money or illegal right along with it.
Exactly. Now let's talk about property. Because in the modern world, property isn't just a piece of land or a car. It's government benefits. It's public employment contracts.
The key word the court uses here is entitlement, right?
That's the magic word. To have a property interest in something like a government job or a welfare check, you must have a legitimate claim of entitlement to it. It can't just be an abstract need or a hope or a desire. The law has to give you that claim.
I think the story of the professor here from the Case Board of Regents v. Roth really clarifies this perfectly.
It's the classic example. You had David Roth. He was an assistant professor at a state university in Wisconsin. He was hired on a fixed one-year term. The contract was very clear, September 1st to June 30th. That was it.
So he teaches his classes for the year, does his job, but he's also pretty politically active, and he's been critical of the university administration.
He has. And at the end of the academic year, the university president simply informs him, "We are not rehiring you for next year." No reason given, no hearing offered, just thanks, but no thanks, goodbye.
So Roth sues. He says, "You're taking my job, my property, without giving me due process."
And the Supreme Court completely shut him down. They said, look at the contract. You were hired for 1 year. You got that year. The contract, the law, nothing gave you a guarantee you'd be rehired. You had a hope of keeping the job, but you didn't have an entitlement. And without an entitlement, there's no property interest, so no hearing is required.
But you have to contrast that with, say, a tenured professor or a teacher with a for-cause contract.
Totally different world. If the law or the contract says a teacher can only be fired for misconduct or incompetence, then that teacher has an entitlement to their job. The state has created a property right, so they can't fire that teacher without a hearing to prove the misconduct actually happened.
It seems like such a technicality, but it's the difference between getting your day in court and just getting a pink slip.
It's everything.
What about something like a nursing home? This was the O'Bannon case. This one is tough.
It's a very tough case. You had a group of Medicaid patients living in a particular nursing home. The government, after an inspection, decided to decertify the home because it was unsafe and substandard.
Okay.
And that meant the government would stop paying the home for those patients, which in effect meant all the patients had to move out.
And these are elderly, often frail people. For them, moving is incredibly traumatic. There's a thing called transfer trauma. They argued the government was depriving them of their home, their property, without a proper hearing.
It's an incredibly sympathetic argument. But the court looked very closely at the law. What were the patients actually entitled to? They had a legal entitlement to financial benefits, to have their medical care paid for by Medicaid. They did not have a legal entitlement to live in one specific building, especially a building that failed safety standards.
So they still got their benefits, just somewhere else.
Exactly. So the government could shut down the funding for that specific home without giving each individual patient a trial-like hearing.
That is harsh, but I do see the legal logic there. Okay, so let's say I pass the test. I do have a legitimate property interest. I'm about to lose my welfare benefits. What kind of hearing do I get? Do I get a full courtroom drama with a judge and a jury and a guy shouting, "Objection"?
No. If we did that for every single government decision, the whole system would grind to a halt. You have to balance accuracy with efficiency. And for that, the court uses the Matthews v. Eldridge test. It's often called the calculus of fairness.
Okay, break down that calculus for us. What are the variables?
It weighs three things. First, the private interest. How much does this decision hurt you, the individual? Second, the risk of error. How likely is the government to mess this up using the current system? And would adding more steps, like a hearing, actually make the decision more accurate?
And the third factor?
The government interest. How expensive and burdensome is it for the government to add all these extra procedural steps?
Okay, let's see this in action. I know you've got a great comparison here.
Yeah.
Welfare benefits versus disability benefits.
This is the perfect example. In a case called Goldberg v. Kelly, the court said you must get a hearing before your welfare benefits are cut off.
Why before?
Because the private interest is literally survival. The court recognized that if you cut off that check, the person might starve or become homeless while they're fighting the decision. The stakes are desperate.
But for disability benefits, the rule is different.
It is. In the Matthews case itself, the court said a hearing after the benefits are cut off is constitutionally okay. The logic, whether you agree with it or not, was that disability benefits, while very important, aren't usually the absolute last line of defense against immediate starvation in the same way welfare was viewed at the time.
And what about the risk of error?
That was the other key. Disability decisions often turn on medical reports, doctor's notes, lab results, x-rays. That's a paper trail. You don't necessarily need a live witness to cross-examine an x-ray, so the risk of making a mistake without a pre-termination hearing was considered lower.
That makes sense. It's a very pragmatic, if cold, calculation. What about when the government seizes physical stuff? We have a fascinating comparison between seizing a house and seizing a yacht.
This comes from a case called Calero Toledo. The government wanted to seize a yacht because it had been used to transport drugs. And they seized it first without any notice and scheduled the hearing for later.
Why could they do that?
Because a yacht has a propeller and a rudder. It can sail away to international waters. If you give the owner a piece of paper saying, "Notice, we're coming to take your boat next Tuesday," that boat will be gone by Monday morning.
Right.
The government interest in securing the asset before it disappeared was so strong that it outweighed the owner's right to advance notice.
Whereas a house...
A house isn't going anywhere. For real estate, generally, the government needs to give you notice and a hearing before they can seize it.
Okay, one last piece on procedural due process. We've talked about getting a hearing, but a hearing is pretty useless if the judge is rigged. We have to talk about the Caperton case, the $3 million donation.
This story sounds like it's from a movie, but it is 100% real. You had a case in the West Virginia Supreme Court. A company, Massey Coal, was being sued and had a $50 million verdict against them.
Okay.
The CEO of that company knew the case was going up on appeal. So during the next election for the state Supreme Court justices, this CEO spent $3 million of his own money to help get one specific judge, a man named Brent Benjamin, elected.
$3 million.
An incredible amount of money.
Yeah.
It was more than all the other donations to that judge's campaign combined.
Wow.
So Justice Benjamin wins the election. And sure enough, the Massey Coal case comes before him. The other side screamed, "You have to recuse yourself." The guy whose case you're about to decide basically bought your seat on this court.
And what did the judge say?
He said, "No, I can be impartial. I've examined my own conscience, and I feel neutral."
I checked my own heart. I love that line.
The U.S. Supreme Court did not love that line. They ruled that due process guarantees a fair trial before a neutral decision maker. And they said, look, we are not saying there was actual bribery here. We're not saying the judge was consciously biased. But the probability of bias, given that one litigant spent millions to get him elected, was so high, so overwhelming, that it created an unconstitutional risk.
So it's about the appearance of justice, not just the reality.
It's just as important. The risk of bias was too high for the Constitution to tolerate.
All right, we've covered the who with state action and the how with procedural due process. Now we arrive at the heavy hitter, the what? This is substantive due process.
And this is, without a doubt, the most controversial, the most debated, and arguably the most powerful part of modern constitutional law.
I used that recipe analogy earlier. Procedural was, did you follow the instructions on the box? Is substantive due process about the cake itself?
That's a fantastic way to think about it. Substantive due process asks, is the government allowed to bake this kind of cake at all?
Explain what you mean by that.
It's the idea that some rights are so fundamental, so deeply rooted in our concept of liberty, that the government simply cannot restrict them, no matter how much procedure they give you. It doesn't matter if they give you 10 hearings in a parade. They cannot pass a law that bans, say, interracial marriage. The law itself is the violation because it's arbitrary and has no legitimate purpose.
Okay, so how does a court decide if a law crosses that line?
They use different lenses or standards of review to look at the law. And for our listeners, you really need to know two key terms: strict scrutiny and rational basis.
These sound like academic jargon, but they basically determine who wins the lawsuit, right?
They almost always determine who wins. Let's start with the easy one, rational basis. This is the default test. It applies to most laws, economic regulations, zoning rules, tax laws, business licenses.
Okay.
For a law to pass this test, the government just needs to show it has a legitimate interest, something like public safety or health or even just aesthetics, and the law just needs to be rationally related to that interest.
So if my town passes a law saying, no giant flashing neon signs in the historic district, and I sue them,
You lose. The government almost always wins rational basis cases. As long as their reason isn't completely insane, the court defers to the legislature.
But then there's the other gear, the big one, strict scrutiny.
This is the hard test. The court puts on this lens when a law touches a fundamental right.
And what does that mean for the government?
It means they have a massive hill to climb. To survive this test, the government has to prove two things. First, that it has a compelling interest. We're talking about things like national security or saving lives, not just making the town look nice. And second, the law has to be the least restrictive means to achieve that goal.
Least restrictive means. It sounds almost impossible to prove.
It practically is. There's a famous saying among lawyers, strict in theory, fatal in fact. If the court applies strict scrutiny, the law is almost certainly going to be struck down.
So the billion-dollar question then is, what counts as a fundamental right that gets you that super strong, strict scrutiny protection?
The court has identified a few different buckets over the years. One is the right to travel, specifically the right to travel interstate. You have a fundamental right to move to a new state and be treated like a full citizen of that state once you're there.
There was a case about this with welfare benefits, right? Sines v. Roe.
Yes, California tried to pass a law that said, if you are new to California for your first year here, you only get the same amount of welfare benefits you would have gotten in your old, less generous state.
They were trying to stop people from moving there just for the better benefits?
That was the idea. But the Supreme Court said it was unconstitutional. You cannot penalize the fundamental right to travel and become a citizen of a new state. Once they are residents of California, they are Californians, period. The law faced strict scrutiny, and it failed.
But what about international travel? Do I have a fundamental right to go to, say, North Korea?
No, you do not. The court has said that is not a fundamental right. The government can restrict travel to specific countries for foreign policy or national security reasons. Those kinds of laws only have to pass the easy rational basis test.
Then we get to the really big bucket, privacy rights.
Right. This is a whole constellation of rights. It includes the right to marry, which covers interracial marriage, same-sex marriage, even the right of prisoners to marry. It includes the right to use contraception, and it includes parental rights, the fundamental right to decide how to raise and educate your own children.
Now, we absolutely have to talk about the elephant in the room, or really the two elephants in the room, because the entire landscape of fundamental rights has shifted violently in just the last few years. We need to talk about abortion and guns.
We do. These are the big shifts that have redefined the law. Let's start with abortion. For almost 50 years, under Roe v. Wade and Planned Parenthood v. Casey, abortion was treated as a fundamental right protected by a substantive due process.
And then, in 2022, came the Dobbs decision.
Dobbs completely overturned that precedent. It fundamentally changed the equation. The Supreme Court majority looked at the Constitution and said, we do not see a right to abortion written in the text. And they announced a new test for unenumerated rights.
Which is?
They ruled that for a right to be considered fundamental under substantive due process, it must be deeply rooted in the nation's history and tradition.
And they looked back at history and concluded abortion wasn't one of those rights.
Correct. They reviewed 19th century laws that criminalized abortion and said, this is not a right that is deeply rooted in our history. Therefore, it is no longer a federal fundamental right protected by the Constitution.
So what does that do to the standard of review? Under Roe, abortion restrictions faced a form of heightened scrutiny. After Dobbs, they face
rational basis review. And that is the key legal shift. It means now a state can pass a law restricting or banning abortion. And if that law is challenged in federal court, the state only has to show a rational basis for it, like an interest in protecting potential life. And as we know, rational basis is a very, very easy test for the government to pass.
Okay, so that's a massive shift in one direction. Let's pivot to guns and the Second Amendment. This has also gone through a revolution, but in the complete opposite direction.
That's right. For a long time, the meaning of the Second Amendment was heavily debated. Then came the Heller decision in 2008, which said there's an individual right to own a gun for self-defense in the home. But the real game changer was a very recent case called New York State Rifle and Pistol Association v. Bruen.
This is the one that threw out all the old balancing tests.
Completely. Before Bruen, when courts looked at a gun law, they would often do a kind of balancing act, weighing the individual's gun rights against the government's interest in public safety.
Right.
Bruen said, stop that. We don't do that balancing anymore. Instead, we look at one thing, history.
How does that work in practice? What does that test actually look like?
It's basically a history hunt. The court established a new test. If the government wants to pass a law restricting firearms, it has the burden to demonstrate that the regulation is consistent with the historical tradition of firearms regulation in the United States.
So if a state like New York wants to ban carrying guns on the subway.
They have to go to the archives. They have to find laws from the founding era around 1791 when the Second Amendment was ratified, or 1868 for the 14th, that banned weapons in similar analogous places.
But there were no subways in 1791.
And that is the enormous challenge for governments now. They have to find historical analogs. If they can't find a law from the 18th or 19th century that looks and feels like the modern law they want to pass, then the modern law is likely unconstitutional. It completely flips the burden.
That is a massive, massive shift. It basically turns lawyers and judges into amateur historians.
It absolutely does. And it means that modern arguments about public safety, statistics about gun violence, those matter much, much less than what the Founding Fathers might have thought about muskets in a town square.
Okay, we have one last category to cover. It's a right that sort of straddles the line between all these concepts, and that's voting.
Voting is a weird one, legally speaking. It is absolutely a fundamental right for citizens 18 and over. But unlike, say, pure free speech where we tolerate almost no regulation, elections have to be regulated.
Right, you need rules.
You need ballots. You need polling places. You need voter registration. You need hours for when polls open and close. If we applied strict scrutiny to every single one of those administrative rules, the entire election system would collapse into chaos.
So how do the courts decide what kind of voting rule is okay and what's not?
It's a kind of sliding scale. If a restriction on voting is severe or seems discriminatory, it gets a much tougher look, something close to strict scrutiny. But if it's a reasonable, neutral, non-discriminatory administrative rule, it gets a lighter review.
Let's compare two famous examples to make this clear. A voter ID law versus a poll tax.
Perfect comparison. Take voter ID first. In a case called Crawford v. Marion County, the Supreme Court looked at an Indiana law that required a government-issued photo ID to vote.
Okay.
The court upheld that law. They ruled that this was a neutral way to prevent voter fraud. It wasn't designed to stop any particular group from voting. It was designed to ensure the right people were voting. The burden on the individual voter going to get a free ID card was seen as minimal compared to the state's interest in election integrity. So it was upheld.
Now, compare that to a poll tax law that says you have to pay, say, $2 to be able to vote.
Completely unconstitutional. That was the Harper case. The court said wealth has absolutely no relationship to your fitness as a voter or your ability to participate in a democracy. It's an arbitrary barrier that discriminates against the poor. That got struck down immediately and decisively.
What about felon disenfranchisement? This one shocks a lot of people. The idea that you can lose your fundamental right to vote forever even after you've served your time?
You can, in many states. And the reason comes from a surprising place. In Richardson v. Ramirez, the Supreme Court pointed to the text of the 14th Amendment itself. There's a specific phrase in Section 2 that talks about a state's representation being reduced, except for participation in rebellion or other crime.
So the Constitution itself seems to hint that you can take voting rights away from people who have committed crimes.
That's how the court read it, because it's right there, explicitly in the text. The court said that states are constitutionally allowed to ban felons from voting, even after they're out of prison. It's a very controversial issue, but it has that textual basis.
Wow. We have covered a massive amount of ground today. I mean, we've gone from a neighbor's BBQ to a company town, from the recipe of due process to the history hunt for gun laws. Let's try to compress all of this into a lightning round recap.
Let's do it. It's a lot to process.
Okay. Point 1, state action. What's the takeaway?
The Constitution is a restraint on the government. Not your neighbor, not the mall, not your private boss. Unless that private entity is doing a traditional government function, like running a whole town, or is pervasively entwined with the state, the Constitution is off-duty.
Got it. Point 2, procedural due process.
If the government wants to take your life, liberty, or property, which includes entitlements like welfare or a tenured job, they owe you two things: notice and a hearing. The timing and formality of that hearing depends on the Matthews calculus. How bad does it hurt you? How likely is a mistake? And how hard is it for the government to do more?
Excellent. Point 3, substantive due process.
This is the can you bake this cake at all question. If a law touches a fundamental right like privacy, marriage, or interstate travel, it faces strict scrutiny and it almost always dies.
Whoa.
If it's just a normal economic regulation, it faces rational basis and it almost always survives.
Perfect. Point 4, the big shifts.
The ground is moving under our feet. Abortion is no longer a federal fundamental right. That power has been returned to the states. The Second Amendment, on the other hand, is now protected by a powerful new test based entirely on history and tradition, not modern concerns about public safety.
And finally, point 5, voting.
It's fundamental, but it has to be regulated. States can require things like voter ID, but they can't charge you a poll tax. And because of the text of the 14th Amendment, states are allowed to prevent felons from voting.
This has been a true deep dive, and it really changes how you look at the news. Instead of just getting angry at a headline, you start seeing the mechanics behind it. You can start to ask, wait, is that state action? What's the standard of review here? Is there a property interest at stake?
It gives you a framework, a way to organize the chaos. And I think there is one final provocative thought that's worth leaving our listeners with.
What's that?
We've talked a lot about history and tradition today. It was the basis for the abortion ruling in Dobbs, and it's the entire test now for gun rights from Bruen. The court is increasingly looking backward to the 18th and 19th centuries to define our rights today.
Right. What did they do in 1791 has become the dominant question.
The question for you, for everyone listening, is this. As our society continues to change, and as technology creates entirely new worlds, the digital space, artificial intelligence, genetic engineering, things the founders could not possibly have conceived of, how well can a 200-year-old tradition govern our future?
Wow. Yeah. Can you really regulate something like AI using laws that were written for muskets? That is the big question, isn't it?
It's the central tension that will define the next 50 years of your rights.
That is a huge thing to think about. Well, thank you for taking this deep dive with us. It's been absolutely fascinating.
My pleasure.
And for everyone listening, next time you see a news headline, just ask yourself that first question. Is that the state? And see where it leads you. We'll catch you next time.